In the complex tapestry of the U.S. legal framework, the delineation between federal and state authority often becomes a focal point for myriad regulatory domains, privacy law being a paramount example. As technology advances at a breathtaking pace, the quest to safeguard personal information has catalyzed an intricate dance between federal oversight and state innovation. This essay delves into the multifaceted U.S. privacy environment, with a spotlight on state privacy laws, epitomized by the pioneering California Privacy Rights Act, CPRA, and the establishment of the California Privacy Protection Agency, CPPA. Through this lens, we unravel the dynamics of federal versus state authority in privacy regulation, the implications for businesses and consumers, and the potential trajectory of privacy protections in the digital age. Federal versus state authority in privacy regulation. The U.S. privacy law landscape is characterized by a dual framework where both federal and state governments have pivotal roles. Federal privacy laws, such as the Health Insurance Portability and Accountability Act, CIPPA, for health information and the Children's Online Privacy Protection Act, COPPA, for children's online data, provide baseline protections across the nation. However, these laws often target specific sectors or types of information, leaving gaps that state legislatures have increasingly sought to fill. This federalist structure allows states to act as laboratories of democracy, experimenting with comprehensive privacy laws that address a broader range of issues and potentially setting the stage for future federal legislation. However, it also leads to a patchwork of regulations that can be challenging for businesses to navigate, especially those operating across multiple states. The tension between federal and state authority in privacy law is not just a matter of regulatory compliance, but also a reflection of deeper philosophical debates about the balance of power within the U.S. legal system and the role of government in protecting individual rights in the digital era. The vanguard of state privacy legislation, California's Privacy Protection Agency. California has long been at the forefront of privacy regulation in the United States, a trend that continued with the establishment of the California Privacy Protection Agency, CPPA, through the passage of the California Privacy Rights Act, CPRA, in 2020. The CPPA represents a significant evolution in the state's approach to privacy regulation, marking the first time a state has created a dedicated agency to oversee and enforce privacy laws. The CPRA itself builds on and significantly expands the provisions of its predecessor, the California Consumer Privacy Act, CCPA, offering consumers greater control over their personal information. This includes the rights to know, delete, and opt out of the sale or sharing of their data, as well as introducing new protections around sensitive personal information and the use of automated decision-making technologies. The creation of the CPPA underscores the importance of institutional structures in enforcing privacy laws. Unlike the sector-specific oversight seen at the federal level, the CPPA has a broad mandate to enforce the CPRA, educate consumers and businesses about their rights and responsibilities, and guide the development of further regulations to adapt to technological changes. This proactive and comprehensive approach to privacy regulation highlights the potential for state agencies to lead in the creation and enforcement of privacy norms, especially in areas where federal legislation is lacking or outdated. Implications for businesses and consumers. The evolving state privacy laws, spearheaded by initiatives like the CPRA and the CPPA, have significant implications for both businesses and consumers. For businesses, the increasing complexity of the regulatory landscape necessitates robust compliance mechanisms and a strategic approach to data management. Companies must navigate not only the specifics of laws like the CPRA but also the potential for similar regulations in other states, each with its nuances. The operational impact is substantial, affecting everything from data collection and processing practices to consumer interfaces and marketing strategies. For consumers, the expansion of state privacy laws represents a significant enhancement of their rights and protections in the digital marketplace. The ability to exercise greater control over personal information offers a counterbalance to the power of tech giants and other data-centric businesses. However, the effectiveness of these rights depends on consumer awareness and the willingness and ability of agencies like the CPPA to enforce the law rigorously. The future of privacy protections in the digital age. As we look to the future, the trajectory of privacy protections in the U.S. will likely be shaped by several key factors. The first is the potential for federal legislation that harmonizes privacy protections across states, providing a uniform standard that reduces complexity for businesses while maintaining high levels of protection for consumers. The second is the role of technological innovation. both as a challenge to privacy and as a tool for enhancing it, through developments in encryption, anonymization, and consumer privacy management tools. Moreover, the global context cannot be ignored. International trends in privacy regulation, exemplified by the European Union's General Data Protection Regulation, GDPR, influence U.S. policy discussions and corporate practices. The interplay between U.S. state laws, federal initiatives, and international standards will be crucial in determining the effectiveness and reach of privacy protections. Conclusion. The U.S. privacy environment, with its blend of federal and state authority, stands at a crossroads. The pioneering efforts of states like California, through the creation of the CPPA and the passage of the CPRA, highlight the potential for state-led innovation in privacy regulation. However, the challenges of a fragmented regulatory landscape and the rapid pace of technological change underscore the need for a coordinated, comprehensive approach to privacy protection. As we navigate the digital age, the evolution of privacy laws in the U.S. will be a critical barometer of our society's values and our commitment to safeguarding personal information in an increasingly data-driven world. State privacy laws. State privacy laws in the United States serve as critical components in the protection of personal information. Unlike the European Union, which has a unified General Data Protection Regulation, GDPR, the U.S. adopts a sectoral and fragmented approach, with various states enacting their own laws to address specific aspects of data privacy and security. Data privacy and security laws. Social Security Number, SSN, protection. SSN protection laws are prevalent across states, aiming to safeguard individuals' unique identifiers from misuse and identity theft. These laws typically restrict how businesses can collect, use, and disclose SSNs, mandating measures to ensure their confidentiality and security. Data destruction. Data destruction laws require companies to properly dispose of personal information, ensuring that it cannot be reconstructed or read after disposal. These laws are designed to prevent unauthorized access to personal data by dictating the secure destruction of documents and electronic files containing sensitive information. Security procedures. Many states have enacted laws that necessitate businesses to implement reasonable security procedures and practices appropriate to the nature of the information to protect personal data from unauthorized access, destruction, use, modification, or disclosure. These laws often require businesses to assess their security practices regularly and update them as necessary to address new or evolving threats. Cookie and online tracking regulations. With the increasing concern over online privacy, some states have introduced regulations concerning the use of cookies and online tracking technologies. These laws typically require websites to inform users about their tracking practices and, in some cases, obtain consent before tracking user behavior. Facial recognition use restrictions. A growing number of states are imposing restrictions on the use of facial recognition technology, citing privacy and civil liberties concerns. These laws often require public transparency, accountability, and oversight mechanisms for the use of facial recognition by government agencies and, in some instances, by private entities. Biometric information privacy regulations. The use of biometrics for identification and authentication purposes has led to the enactment of biometric information privacy regulations. These laws regulate the collection, use, storage, and destruction of biometric data, such as fingerprints, voiceprints, and facial geometry, to protect individuals' privacy. Illinois Biometric Information Privacy Act, BIPA, 2008. The Illinois BIPA stands as a landmark law in the realm of biometric privacy, imposing strict requirements on businesses for the collection, use, and storage of biometric identifiers. It grants individuals the right to sue for damages, making it one of the most stringent biometric privacy laws in the U.S. Recent developments. The landscape of state privacy laws in the U.S. is continually evolving, with recent years witnessing the introduction of comprehensive data privacy laws in several states. California Consumer Privacy Act, CCPA, 2018. The CCPA marked a significant milestone in U.S. privacy law, granting California residents new rights over their personal information and imposing obligations on certain businesses regarding the collection, use, and sharing of consumer data. California Privacy Rights Act, CPRA, 2020. The CPRA builds upon the CCPA, introducing additional protections for consumers' personal information, establishing the California Privacy Protection Agency, and expanding consumers' rights, including the right to correct inaccurate personal information and the right to limit the use of sensitive personal information. Virginia Consumer Data Protection Act, VCDPA, 2021. The VCDPA represents Virginia's foray into comprehensive data privacy regulation, providing consumers with rights similar to those under the GDPR, such as access, correction, deletion, and portability of personal data, as well as the right to opt out of certain data processing activities. Colorado Privacy Act, CPA, 2021. The CPA mirrors the consumer rights provided by the VCDPA and CPRA, including a unique provision that requires data controllers to conduct data protection assessments for certain processing activities that present a heightened risk of harm to consumers. Nevada Privacy Law and Amendment, COVALENTS 1B260, 2019-2021. Nevada's privacy law, as amended, focuses on granting consumers the right to opt out of the sale of their personal information, with a broad definition of sale that encompasses various forms of data sharing for monetary consideration. Connecticut Data Privacy Act, CTDPA, 2022. The CTDPA aligns closely with the VCDPA and CPA, offering comprehensive data protection rights to consumers, including the rights to access, correct, delete, and port their data, along with the right to opt out of targeted advertising and the sale of personal information. Utah Consumer Privacy Act, UCPA, 2022. The UCPA sets forth a framework for data protection that includes consumer rights to access, delete, and obtain a copy of their personal data, along with transparency and accountability measures for businesses that process personal information. California Age Appropriate Design Code Act, AB 2273, 2022. This act introduces groundbreaking requirements for online services likely to be accessed by children, mandating privacy by design principles and enhanced protections for young users' personal information. Other significant state acts and laws. Beyond these highlighted laws, numerous other state acts and regulations address various aspects of privacy and data protection, reflecting the diverse and evolving nature of privacy concerns across the U.S. This patchwork of state laws underscores the complexity of navigating the U.S. privacy landscape and the ongoing efforts to balance innovation with the protection of individuals' privacy rights. Conclusion. The U.S. privacy environment, characterized by its state-driven legislative approach, continues to evolve rapidly in response to technological advancements and growing privacy concerns. The enactment of comprehensive state privacy laws demonstrates a significant shift towards stronger privacy protections and greater consumer control over personal information. As technology continues to advance and data becomes increasingly integral to our daily lives, the development and harmonization of privacy laws will remain a critical issue for policymakers, businesses, and individuals alike. U.S. state privacy laws. A detailed examination of data breach notification laws. The landscape of data privacy in the United States is a complex mosaic of federal and state regulations, with state data breach notification laws playing a pivotal role in shaping the privacy environment. Unlike a uniform federal standard, these state-specific laws provide a varied approach to how data breaches are handled, requiring organizations to navigate a labyrinth of legal obligations. This essay delves into the elements of state data breach notification laws, highlights key differences among states, and reviews recent developments, including significant legislative amendments in states like Illinois and Massachusetts. Elements of state data breach notification laws. State data breach notification laws are crafted to ensure that entities that collect and store personal information are accountable for its security and are obligated to inform individuals when their data is compromised. The core elements of these laws include definitions of relevant terms, conditions for notification, and subject rights. Definitions of relevant terms. Personal information. Typically, state laws define personal information as data that, when combined with other information, can be used to identify an individual. This often includes names combined with social security numbers, driver's license numbers, financial account numbers, or health information. Some states have expanded definitions to include biometric data and digital identifiers such as email addresses combined with passwords or security questions. Security breach. A security breach is generally defined as unauthorized access to or acquisition of computerized data that compromises the security, confidentiality, or integrity of personal information. The threshold for what constitutes a breach varies, with some states requiring a likelihood of harm to the individual before triggering notification requirements. Conditions for notification. The laws specify which entities are responsible for notifying affected individuals. This often includes businesses and government entities that own or license personal information. Timelines for notification also vary, with most states requiring notice to be provided without unreasonable delay, typically within 30 to 60 days of discovering the breach. The manner in which notifications must be made is also specified, including written, electronic, or, under certain conditions, telephonic notifications. Some states allow for substitute notice methods, such as email or public posting, if direct notification would be overly burdensome. Subject rights. Credit monitoring. Several states require that entities offer free credit monitoring services to affected individuals if the breach involves social security numbers or other financial information. Private right of action. Some state laws provide individuals with the right to sue organizations that fail to comply with data breach notification requirements, potentially leading to significant legal and financial repercussions for non-compliant entities. Key differences among states today. The variation among state laws creates a challenging environment for organizations operating across multiple jurisdictions. Key differences include the scope of personal information protected, thresholds for triggering notification requirements, and the specifics of notification procedures, including who must be notified, the timeline for notification, and the acceptable methods of notification. Additionally, the availability of a private right of action and the requirements for offering credit monitoring services vary significantly among states, influencing the severity of the consequences for non-compliance. See recent developments. Recent years have seen a flurry of legislative activity as states update their data breach notification laws in response to evolving cyber threats and public expectations around data privacy. Illinois HB 1260. Illinois House Bill 1260, effective in 2020, expanded the definition of personal information to include biometric data and health insurance information. It also introduced stricter requirements for entities that suffer a breach, including timely notification to the state attorney general and the provision of credit monitoring services when social security numbers are involved. Massachusetts HB 4806. Massachusetts House Bill 4806, effective in 2019, broadened the definition of personal information and introduced mandatory credit monitoring services for breaches involving social security numbers. It also eliminated the previous cap on civil penalties and required entities to offer a detailed description of the breach, the types of personal information compromised, and the steps affected individuals should take in response. Other significant state amendments. Other states have similarly updated their laws, with changes ranging from expanded definitions of personal information to enhanced rights for affected individuals, such as the right to receive credit monitoring services or to take legal action. These amendments reflect a growing recognition of the need for robust legal frameworks to protect personal information in the digital age. Conclusion. The patchwork of state data breach notification laws in the United States presents a dynamic and challenging landscape for organizations and legal practitioners. While these laws share common elements, significant differences in definitions, notification requirements, and subject rights necessitate careful attention to detail and a nuanced understanding of legal obligations across different jurisdictions. Recent legislative developments indicate a trend towards more stringent requirements, reflecting an increasing emphasis on data privacy and security in the digital era. As the regulatory environment continues to evolve, staying abreast of these changes will be crucial for ensuring compliance and protecting the rights of individuals in the face of ever-present cyber threats.